and good afternoon, everyone. My name is Kevin Hyde. I'm a partner at Foley & Lardner and practice exclusively in labor and employment law. The other presenters today will be my colleagues Lenny Fiegel, who is also with me here in Jacksonville, who practices labor and employment law, and finally Mark Newberger in our Miami office. We'll talk about aspects of this law that I know you've had a lot of attention about. We're here today to talk about the mandatory E-Verify program that is now part of the new law. So we'll go to the next slide and you'll see quickly the agenda that we're going to follow. And as previously indicated, we hope to have enough time to answer the questions that undoubtedly we know that you have. So I'm going to start off and spend just a very few minutes to look at the policy considerations behind the new law. You no doubt have heard a lot about it in the news, particularly some activity even as recently as last week with some work stoppages. Then we're going to go into depth about the law's various requirements and specifically those provisions that affect employers and particularly private employers, because that's where the law has now been extended to. And then finally, just some open questions that will be addressed about how the E-Verify system, to which we're all now subject to, how it works and how you can make it work for your company. Next slide, please. So let's talk about some policy considerations. You no doubt heard that in the recently enacted legislative session, which went from March to May, this was one of the hot topics that was present in a lot of the discussions at the legislature. The law easily passed the Republican-controlled legislature and went quickly to the governor's desk. You'll see here on this slide information directly from Governor DeSantis' website as he was signing the law. And this really gives us an idea of the policy implications and the policy thought behind the law. So the governor said, for instance, the legislation I signed today gives Florida the most ambitious anti-illegal immigration laws in the country, fighting back against reckless federal government policies and ensuring Florida taxpayers are not footing the bill for illegal immigration. And you've no doubt heard, particularly since the governor has launched his presidential campaign, a discussion about this law consistent with the views that he has. Real briefly, and this will be gone over in greater depth by Lenny and Mark, the law requires private employers with 25 or more employees to use the E-Verify system beginning July 1, 2023. That's why we wanted to get this information out there, because the law goes into effect in about 3 weeks. The bill also, or now law, also expands penalties for employers who fail to comply with the E-Verify requirements, including, and this is new, possible suspension and revocation of employer licenses and very specific penalty for employers that knowingly employ illegal aliens. So we see here that the law does have some teeth, as well as creating a possible third-degree felony for an unauthorized alien to knowingly use a false ID document to gain employment, and prohibits a county or municipality from providing funds to any person or organization for the purposes of issuing IDs or other documents to the illegal alien. So it affects both the potential user and the county or municipality. And also, finally, one of the provisions is that illegal aliens will no longer be able to permitted to rely on out-of-state driver's licenses. And this will be further discussed, but basically the state of Florida cannot rely on the driver's license improperly issued to someone else in another state. Next slide, please. Again, this is from the governor's website, which gives just a basic visual image of what the law was intended to do. So as we've mentioned and we'll discuss, E-Verify is the component that I'm sure as private employers is the one you're thinking about the most. Possible suspension of licenses if you knowingly employ illegal aliens. There is a lot of discussion, and we'll talk about this further, about human smuggling and what that means. And I'll suggest, as you will hear, that it's a much broader definition than what you might have heard about just in the news. There was specific money set aside for transportation of unauthorized aliens to relocate illegal immigrants to sanctuary jurisdictions, $12 million set aside for that. And you've probably seen some news in just the last few days where the state of Florida has talked about efforts that were done for that. As we talked about, banning local governments from issuing local identification documents to illegal aliens and invalidating out-of-state driver's licenses. And then finally, something that it may not affect you if you're not in healthcare, but just to know about, requiring hospitals to collect and report healthcare costs for illegal aliens. So clearly a wide sweeping law. Next, please. As we said, this goes into effect on July 1, about 3 weeks. It was signed into law just about 3 weeks ago or so on May 10th. And again, a statement from the governor, just to give you the policy implications. We propose strong legislation to curb illegal immigration, both deterring illegal immigrants from coming to Florida, but also holding people accountable in Florida who are involved in illegal immigration. We made that promise. We said we would go big, and today we deliver on that promise. Even the New York Times admitted that this is the strongest legislation against illegal immigration in the country. I think you see from the governor's own statements his commitment to this idea and to this law, and that will be seen as we talk about the depth and breadth of this law. Next. We won't take time to read all of this, but there has obviously been a lot of reaction to the law, and one of the things that has been discussed is what is the impact going to be, particularly in 3 or 4 segments of our economy: construction, hospitality, healthcare, and agriculture. And you see here a statement from the Florida State Director of American Business Immigration Coalition, feeling like this was going to adversely affect the workforce that we have in Florida, and perhaps even cause people to move out of state. Next. Again, some ideas or some thoughts about what might happen as a result of the law. You'll see here an immigration attorney in Palm Beach who volunteers with the Farm Worker Coordinating Council, a quote, panic over the law, that some businesses have begun issuing notices of termination in order to get ahead of what they fear might be their compliance issues. Next. So you may have heard this on June 1, just a few days ago, there was a so-called Day Without Immigrants, which was basically an employer work stoppage throughout businesses across the state as a way to show what the possible impact of the law is should certain parts of the workforce not be able to comply with this law. And so this was a very tangible, visible demonstration that people were willing to make to show what the impact of this law was going to be. As we're going to discuss going forward, the main component is on E-Verify. Currently, there has not been a challenge, a legal challenge to this law, and particularly the use of the E-Verify system. And because E-Verify is already implemented in so many other states, 27 to be precise, it's not likely that a lawsuit challenging the state's right to enact this type of law would even be successful. So as we talk about this, we should all assume that A, the law is in place, which it is, and that it is likely to remain in place. Next. So I'm going to turn it over now to Lenny to really get into the guts of the law, but I think understanding the policy implications of it and why it came about this way will give you an idea of some of the implications and of the specifics of this law going forward. Lenny?
Thanks, Kevin. Yeah, the policies are important because you'll see it flow through the whole portions of the law. So next slide. What we're going to talk about is really what we know from the law and some what we're going to call questions where we don't really have the exact answer right now. A couple things to highlight. The law was enacted in essentially 2 months. That's a very short time and quite frankly, hastily written. Because of that, it's not as comprehensive as other laws. And because therefore, there's lots of outstanding questions, some of which we'll address a little bit later during my presentation. As Kevin said, the law takes effect July 1st, 2023, and it's anticipated to impact Florida's agricultural, construction, and hospitality sectors the most. New slide. So what do we know it does? As Kevin kind of highlighted, it prohibits local governments, so that's municipalities, counties, from funding any person or organizations to issue their own documentation to undocumented immigrants. Also allocates millions of dollars for Governor DeSantis' migrant relocation program. As Kevin highlighted, I think it was in the news yesterday, the state of Florida was involved with 2 migrant relocation flights, I believe, from Texas to California. It also creates a 3rd-degree felony for any undocumented person who knowingly uses a false ID document to gain employment. And that's a criminal charge, and that's up to a 3rd-degree felony in Florida can have You can be sentenced up to 5 years in prison, can include up to $5,000 fine and potentially 5 years of probation. So it's a significant teeth. Next slide. As Kevin said, it also invalidates driver's licenses issued to undocumented people from other states. Currently, there's 19 states, which we've listed below, which is District of Columbia, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, and numerous other states that have enacted laws that enable undocumented persons to possess a driver's license. So one of the key things here is it's involved in the law. It says a specific class of licenses. Just so you all know, most of the time when it's a different from a different state with a different undocumented person, it's often referred to as in a different manner. For instance, Delaware describes it not as a driver's license, but as a driving privilege card. Maryland describes it as a non-compliant driver's license. Other states, however, it looks very similar. New York and New Jersey just have different markings or a different small different notification on the license that makes it so you can just determine that it's not a true a license for a valid documented person. One of the things that the Florida Department of Highway and Safety Motor Vehicles, it's pursuant to the law, is required to maintain a list on its website of the out-of-state classes of driver's licenses that are invalid now under Florida under this law. I checked again this morning. There's no list set up yet. Hopefully it'll be put out sooner than later. Other provision of the law is it eliminates any discretion for law enforcement to issue a citation. So if they catch somebody with an improper license, they are supposed to immediately issue a citation, no discretion to the undocumented person. Just to note some exemptions from the needing a driver's license. So anybody who's operating a road machine or a farm tractor temporarily on a roadway don't need a driver's license for that. That's important from the agricultural employers. Also, if you're operating a golf cart, you don't need a driver's license. Next slide, please. So what don't we know regarding with the law invalidating driver's license? We have no idea how this impacts insurance. For instance, if you have an employee that typically works outside of Florida as a driver or delivery person, and that individual occasionally enters the state of Florida for business purposes, what happens if that employee is involved in an accident? Does their insurance cover them? I mean, does your insurance cover that accident? Because as written, that person is not operating with a valid license. So you need to make sure you are touching base with the insurance broker if any of those, if that situation is a possibility. Next slide. As Kevin kind of hinted around, it also requires hospitals that receive Medicare dollars to inquire about a patient's immigration status. What the law requires is that now hospitals that receive Medicaid dollars have to revise their admission or registration forms to include a question that asks whether the patient's a U.S. citizen, lawfully present in the U.S., or is not lawfully present in the U.S. The admission form also must state that regardless of the response provided will not impact the person's care or result in any reporting to ICE or any other immigration officials. Hospitals will also be required to provide a quarterly report to Florida's Agency for Healthcare Administration detailing the number of patients that visited the emergency room or were admitted to the hospital in each category of the citizen status question. And this flows through where they're trying to figure out how many people are being treated. I mean, what is the policy of the law is to combat illegal and undocumented immigrants, and to figure out how much tax dollars are being provided and along those items. This report demonstrates what they're trying, how that policy is being fulfilled. And one of the things that's important is none of the individuals' names are going to be disclosed. It's just numbers that are required in the report. Next slide, please. We also know that the law prohibits employment of undocumented persons. The law specifically says it's unlawful to knowingly employ, hire, recruit, or refer employment for an undocumented person. This is not new. It's not any new item under the law. But what it does is it institutes penalties for violations that are being enforced by the Florida Department of Economic Opportunity. As a reminder, that's the department that follows up or handles unemployment benefits. And it requires the FDEO to issue an order requiring repayment of economic incentive awards given to the employer if it's determined there's a violation. It also must place the employer on a probation of 1 year and require the employer to provide quarterly reports demonstrating compliance, essentially that you're not employing undocumented persons. The violations, though, for private employers, it takes place within a 24-month period, which takes place within a 24-month period of any previous violation. So if you're found to have knowingly employed 1 or 10 undocumented immigrants, you can have your business license suspended for up to 30 days. And it goes on, if you employ 11, if there's 11 to 50 improper or undocumented immigrants that are employed, the suspension can be up to 60 days. Next slide, please. So now we'll talk about employment verifications. This is something that also is not new. Law states private and public employers must verify each new employee's employment eligibility within 3 business days after the first day that the new employee begins work. Okay, and this is basically, you must use the E-Verify or production of documents required under I-9. Again, this is nothing new, this provision. Every employer is supposed to do this. Public employers must use E-Verify, states in the law. This, again, not new. This was required under the law passed in 2021. And just for clarity, E-Verify is a web-based system used by the federal government to confirm the eligibility of employees. Also, per the 2021 law and a subsequent executive order by Governor DeSantis, any contractor with the state agencies that provides goods or services is required to use E-Verify. So it's built into the state agency contracts. It's also, there has to be a representation for anybody who's part of that contract that will require subcontractors to also perform E-Verify. Next slide. So now we move on to what private employers must do. So private employers with 25 or more employees must use E-Verify for new employee hires. This is the big new item of this law. Similar to requirements under I-9, the verification must occur within 3 business days after the new employee begins working. There's a caveat here, which is actually a pretty good provision. It says if the E-Verify system is unavailable during the 3 business days after the first day of the new employee begins working, the employer will still need to complete the I-9 form and to verify employment eligibility. We also advise that you take screenshots or pictures demonstrating that the E-Verify system was down during those days. The private employers with 25 or more new employees will be required, or 25 or more employees were required to certify on their annual tax returns that annual state tax returns, they are in compliance with this requirement when they're contributing to the state's unemployment compensation and reemployment assistance system. The statute defines employee to be an individual filling a permanent position who performs labor and services under control. It does not, it specifically states, it does not include independent contractors or individuals hired for casual labor. It's performed entirely within private residence. But casual labor under the statute is it's unoccasional, it's infrequent type of labor that the maximum is something about 200 hours in a year. So it's definitely infrequent. But the important there is the statute defines the employee as a permanent position. New slide. Compliance. So who's responsible for enforcing this? Same Department of Economic Opportunity is responsible for enforcing these E-Verify requirements. And the Florida, it's notable here, the Florida Policy Institute issued a statement stating that the FDEO does not have a robust enforcement section, and creating new positions to oversee the provision will result in significant costs. It's unclear where that, whether that will be funded by the budget. It's not, there's no appropriation in this law for specifically for enforcement of the E-Verify system. Also, as Kevin highlighted, there's a graphic on the governor's website that states that employers who fail to use the E-Verify will be fined $1,000 a day, or up to $1,000 a day. However, the penalties apply only after an employer fails to use the database 3 or more times within a 2-year period. So it's not immediate. And I'll go over now. Can you go back? One of the important things here is the department has to, under the law, if there's a violation of the E-Verify system, the employers are supposed to be provided notice of the determination of the violation and provided 30 days to cure the non-compliance. That's an important factor, because if you do make an error, now you can comply, you can improve, fix the non-compliance, and hopefully then you won't face any potential fines. You also, as part of a violation, can have your licenses suspended in addition to the $1,000 per day fine. Next slide. Also, employers must retain a copy of the documentation provided to verify the employment for the last 3 years. The bill, however, doesn't tell us what the 3-year period goes from. It doesn't say if it starts from the date of employment or if it extends through the last date of employment, such as the termination date. So we're advising clients right now is follow the federal regulations. What that says is it's an either or. You have to keep it up to three years from the date of employment starts, or 1 year after the date of employment ends. And if further guidance comes out, hopefully we'll update our advice. Next slide. Law also states that employee leasing companies that contractually place on the client companies the obligation to conduct the E-Verify are not required to do the E-Verify also. So leasing companies can contractually require the client companies to do the E-Verify compliance. Also, the law makes clear that if it's a properly classified contractor or subcontractors, that the company should not, would not have to comply with the E-Verification. Next slide. So what don't we know about the E-Verify law? I'm just going to highlight a few. Okay, we don't know what it means by new employee hire. There's no guidance. There hasn't been anything issued out. So it's unclear if somebody's rehired in 6 months, 1 year, 2 years. It's unclear when someone could be deemed a new hire. Under guidance regarding the I-9 form from the federal government, 3 years is the magic. It seems to be the magic number. So if an employee is rehired within a 3-year period, an employer has an option. They can either start a new I-9 form, such as where it would be a new employee, or they can complete just the section 3 of the I-9, which actually says it's a rehire. You don't have to present as much information. And what we believe right now is saying, if you as a company or employer are typically requiring a new I-9 for every rehire, then you probably need, we advise you do E-Verify at this time if you have 25 more employees. But if you typically only do section 3, which is the rehire, then we think you're probably okay at the moment. But there's no promises that because there is no guidance. But as I said before, remember, if that's a violation, you should be able to provided a 30-day cure period. And that's something you can easily fix. Next slide. It's also not clear what a permanent employee is. Again, there's no guidance, there's no definition, but we feel pretty confident that it likely excludes any seasonal or temporary workers. Another question is when you're counting employees, do you have to aggregate employees from, affiliated or related companies? Under some employment laws, that often can happen if there's a centralized control or an enterprise. There's no guidance here if we need to do that here. And how do you have to count employees outside the state of Florida? So what we anticipate is you could apply, any businesses that transact in business and employ 25 or more employees, whether they're full-time or part-time, in the state of Florida probably should do E-Verify. Now, if you have related companies, but you have separate EINs and separate unemployment accounts, we don't think you probably don't have to aggregate those employees together to see if you have 25 or more. But if you have affiliated companies and you have, the same unemployment accounts or, the same EIN, we would advise you that they aggregate the employees to see if you have 25 or more. Next slide. As Kevin said, the law also revises the definition of human smuggling. So the new law defines a person who knowingly or willfully transports into this state an individual whom the person knows or reasonably should know has entered the United States in violation of law and has not been inspected by the federal government since his or her unlawful entry from the other country commits a felony of the 3rd degree. Also, there's some factors that can raise the penalty to a 2nd-degree felony if it's the transportation of a minor or transportation, commits five or more offenses, which is more transportations, or a prior conviction. The Florida Department of Law Enforcement is the entity that will be enforcing this law. That's based on prior law and the executive order by the court, or executive order by the governor, sorry. New slide. So what about, the human smuggling provision has some questions. I mean, there's no doubt. One, there's no term as to how far back somebody needs to look to see about entering the United States. So if somebody enters the United States back from 20 years ago, is that still valid? Is that could that lead to a violation of this law and criminal liability? It's unclear. What does transports mean? If you pay for somebody to have a bus ride, would that count? Again, we're going to need some further guidance on this law because this provision especially, there's lots of holes and ambiguities. It's also, there's no definition or description of what inspected by the federal government means. So this provision is likely going to, has been proposed, and it probably is true, affect employees or families where some individuals are properly documented and others aren't. I mean, this is why there's some concern where people are leaving the state, especially families that have some undocumented undocumented persons. And it's also, as an employer, you need to be careful because if you are employing somebody that is undocumented, and for instance, you have a sales meeting down in the state of Florida, and you're providing travel for them to get into the state of Florida, that could create a problem under this provision. Next slide. Now I'm going to pass on to my colleague Mark. He'll kind of go through the E-Verify system and the process.
Thank you, Lenny, but hang on for a moment. You addressed this, but I'm looking in the chat room, and we have a number of questions regarding, what you and I as labor lawyers call integrated enterprise, and how you count to the 25 threshold. What if I just set up a new LLC every time I get to 24 employees? There's a number of questions on that. You want to just kind of go back over what you said?
Sure. So I think it's going to depend on under other laws in the integrated enterprise. It'll look at, do you have the same management? Do you have the same board? Who are the individuals that are running the company? Here, I think it's going to depend on, I mean, just creating a new LLC that's in the same exact business, industry, I think could potentially be problematic. And it clearly goes, I mean, it also, it could subject you to potential liability. With that said, I think it's going to depend on the circumstances. Marcus brings up another question that is not raised in the law, is when and how do you count employees? I mean, the number of employees almost always varies. I mean, if you hover around 23, 24 employees and you hire one, does that mean you have to now, from moving forward, every new employee has to be verified? Probably right now. Other statutes, you look at an analysis over time to deal with these variations. But in this law, there's no description or analysis of how or when the number of employees is to be determined.
Great. Thanks, Lenny. I thought now would be a good time to kind of address those. Hopefully we knocked off a few questions, but if we didn't and you still have issues, put more stuff in the chat room, and at the end, we'll come back to you. Next slide, please. So what I'm going to talk about is the E-Verify process. But before we get into the specifics of E-Verify, you have to take a review course in the I-9 process, because you cannot do E-Verify until you've done the I-9. It's a sequential process. The Form I-9 was created by a federal law passed in 1986, the Immigration Reform and Control Act, that said every employer in the United States has to get a Form I-9 within the first 3 days of employment from every employee. It's one of the few employment laws that has no exceptions and no thresholds. And so that's number one. If you haven't been in compliance with the I-9 process and you're a Florida employer, now's the time to do it. The Form I-9 has 3 specific sections that go to the purpose of the I-9 form. Number one, the employer completes the section, the employee completes section 1 about some basic demographic data. The employer completes section 2, which involves a review of documentation provided by the employer that does 2 things. It says, yes, this is the identity of the person in question. This, in fact, is Mark Neuberger. And 2, it says Mark Neuberger is legally able to work in the United States for the job you're about to hire them. And there's a lot of ways and a lot of different documents that will go to meeting that proof. And so you have column A on the form. Column A is the type of proof that will show both identity and work authorization. The best example of that is a U.S. passport. It has my picture in it, and to get the passport, I have to be a citizen of the United States. If I'm a citizen of the United States, I can work in any job. But a lot of people don't have that, and they have alternative forms of documentation. So if you can't satisfy column A, you can do one from column B and one from column C. And one goes to identity, to work authorization. That would be like a Social Security card, by way of example. And the other would be my state certified driver's license, which has my picture and basic demographic data. It's important for employers to know you can't pick and choose what you require. You must allow the employee all the available options that the I-9 allows them, and they're innumerable. Once the employee presents the documents to the employer must review and certify on the form that I've looked at those forms and they appear to be authentic. The law does not require you to be a certified document examiner, but it does charge you with the basic responsibility of trying to spot fraud and abuse. And one of the best ways to do that is to refer to the I-9 employment. There's a manual for employers for the Form I-9. It's available on the federal government website. And there they give you multiple examples of all the different types of documentation. And under the federal law, you did not have to keep copies of the documents once the employer presented it to you and the employer representative authorized and certified on the form that they reviewed them and they looked okay. But under the new Florida law, employers must keep the underlying documentation. Why? Because it's believed that one of the scams and one of the ways to evade compliance with the I-9 process is to show some documents, the employer says yes, and then there's no proof later on for anybody to audit or second guess as to what those documents were. Now, when the employer authorizes the veracity of the documentation on the I-9 form, they do so under penalty of perjury from the federal government. But here again now, the state of Florida has imposed the obligation to maintain documents, so it's possible to go back and audit and see if there was any hanky-panky. The I-9 form must be completed before the third day of hire. If you can't verify by then, the employer must put them off the payroll until they can identify both their identity and work authorization. The I-9s must be maintained for a period of time. Under the I-9 process, you're subject to audit by the Department of Labor or the immigration authorities. And they do these audits like with 72 hours notice. So even before we got to the new law, there were heavy obligations on every employer. Next slide, please. So now we're going to talk about the E-Verify process. Going back to the I-9, one more comment. When you're audited by the federal government for I-9 compliance, they look at two things. Is this person legitimate? Do they truly have the work authorization? And as Lenny pointed out, if you knowingly employ someone who's not properly authorized, that's a crime. But under the I-9 process, even technical violations can be subject to civil fines that can quickly mount to thousands of dollars or more, and even tens of thousands of dollars. What I'm saying is the person's perfectly legal. Mark Neuberger was born in Brooklyn, New York. He presented his U.S. passport, and there's no question that Mark can work in the United States, but they didn't fill out the form properly. There are fines and penalties for that. Okay, let's switch to E-Verify. So E-Verify is an internet-based system developed jointly by the Social Security Administration and USCIS that compares the information entered on the I-9 form to what the government has in its records and database. So I know a number of you asked questions about timing. So you cannot do E-Verify until you've completed the I-9, and all of this has to be done in the first 3 days of employment. The good thing about the E-Verify process is it's free, and when it works, it's quick. You get an almost instantaneous response of one type or another. And if you're going to use E-Verify, although this isn't a legal requirement, this is Mark Neuberger's requirement. Do not do this without reading the manual cover to cover. It's not that long. It's not that hard. You're not going to remember everything, but you're going to keep it there so you can refer back. And you're going to see why as we get into the next slides. Please. So before you can participate in the E-Verify process, you got to sign up. You have to enroll your company. To do that, it's all done online. You have to provide some basic information, and you got to agree to the rules of the road, because if you skip to the last bullet point, you are formally going to sign something called a Memorandum of Understanding between your company and the federal government as to what the rules are about participating in the E-Verify process. That's significant because if you mess around, again, you're lying to the federal government, and that's a crime. And they did that intentionally. You set up a contact point for your account. It could be one or more people. Don't make the mistake of not knowing the passwords so that if that employee leaves for whatever reason, all of a sudden you're shut down. Kevin, Lenny, and I spend a lot of time with employers these days. who fired an employee, and they're calling us to get the laptop back for him, get the iPhone back for him, and get back all the passwords they have. Think about this before it happens and have a backup plan. So you put in various information as I've outlined there, you review the user manual, you sign the MOU, and you're ready to rock and roll. Next slide, please. Here are some musts, and this is going to go, these next two slides are going to go to some of the questions I saw in the chat room while my buddies were talking. You have to follow the E-Verify procedure for every employee. They call it creating a case. That's their terminology for running an individual through the E-Verify process. You can't pick and choose. Now, under the Florida law, because if you have 25 or more employees, it's going to be mandated. But in the past, right, you couldn't pick and choose who goes through E-Verify. It's an all or nothing obligation. You have to put up certain posters in the workplace and in the applicant processing area that tells the applicants they are going to go through E-Verify. That's a good thing, because if your applicants see it and they go, oh my God, we're going to go through E-Verify, you're going to get some self-selection. If I know I'm not going to go through it, I'm going to just take myself out, which makes it a lot faster and easier for the employer, who doesn't have to deal with the problem of someone they hired but can't pass E-Verify. As I said, you must have a Form I-9. You must have a social security number from each person. You must ensure that if you use a Form B, that you have a photo. You're going to see why. Not take a photo, use the photo that they gave you. And again, you're going to create a case and have all this done by the 3rd business day. Next slide, please. So these are the posters. And they're designed for 2 purposes. One, to signal you comply with E-Verify, but 2, and this goes back to the Immigration Reform and Control Act that created the I-9, and it's again with E-Verify, the government is always afraid it's a good thing, bad thing, right? They want you to verify, but these processes can be used to discriminate against people based on national origin or other illegal categories, and they don't want you to do that. That's one of the reasons why it's an all or nothing proposition. You don't just run people with Hispanic last names through E-Verify. That will get you in trouble. Next slide, please. Okay, so if you're in E-Verify, what you must not do, and I believe this was a question in the chat room, you must not pre-screen. So there's no early doing this. It's only after an offer of a verified offer, bona fide offer of employment has been accepted, that you can start the I-9 process and the E-Verify process. You can't do that because they're afraid you're going to screen out people based on national origin if you do it earlier in the process. You cannot specify or request which forms of I-9 documentation an employee must use. If it's valid under the I-9 process, look at the employer manual, and they provide it to you, you have to go with that. You can't say, I only want passports, I only want driver's license. You cannot do that. As I mentioned, these processes, the government's concerned about being used to discriminate. You must create an account for, as they call it, a case for each employee. You cannot create an account or run people through E-Verify before you sign the MOU. And this goes to a question. So the law does not require you, the Florida law does not require you to go back and E-Verify everybody. In fact, you can't do that. And even if you were a participant in E-Verify, now I'm talking, that doesn't make sense. You can't go back and E-Verify your employees. There's only one exception to this, and that is if you become a government contractor and you hadn't been doing it under the terms of the government contract, and that's a federal government, they might make you go back and E-Verify people, especially if there's national security issues involved with the contract. But that's a one-off. So you're not going back over your existing workforce, even under the Florida law. The Florida law specifically says it's only for new hires, and that's what you're going to do. And then when you get a mismatch, you don't automatically terminate them because there's a process. Next slide. And look, if you do criminal background checks or you've used E-Verify before, there are mistakes in the system, right? Social security number gets transposed inappropriately by mistake. there's errors in records. And the process is designed that if you put a case through and it gets kicked back out, you don't just automatically stop and say, okay, I can't hire Mark. You have to go back through the process to try to see if it's a mistake that's fixable or if it's a mistake that's not fixable. So the E-Verify process has mechanics for how you do this. I don't want to go through all the details. It's laid out in extreme detail and in plain English in the E-Verify manual. But you have to go through that process and allow the employee the opportunity to clean up what might be a mistake. Next slide. So when you do it, you get an almost instantaneous result. And there's a lot of things that might come back. Number one, green flag, good to go. The information matched the computer records from DHS and SSA. You might get E-Verify needs more time. There's something wrong on their end as to why they need to do that. You might get what's called a tentative mismatch or non-confirmation. It didn't match. That sets up the process of going back and trying to fix it. You get case in continuance, closed case and resubmit, final non-confirmation. That would be this person's no good and you can't hire them. And there's some timelines here. Remember, if 3 days go by and they're not verified, you can't employ them. You got to put them off the payroll till the process gets fixed. Next slide, please. So if the initial case results in a tentative mismatch, they call it a non-confirmation, the employer must notify the employee so the employee can decide whether to take action. Again, this is a good thing. It's self-selection because the employee may say, whoops, I got caught. I'm out of here. When they take themselves out, that's a good thing. But again, it may be a mistake and they have to be given the opportunity. And these are, again, some of the other results and how to handle them. They're laid out in great detail in the E-Verify user manual. Next slide. Kevin, I'll turn it back over to you and then we'll take questions.
So, and thanks, Mark and Lenny. The conclusion is be aware of the July 1 date, which is quickly coming upon us. There is and you'll see this in the questions that you're asking, which we'll answer in a moment. There is still a lot of uncertainty in whether the various agencies will provide any further guidance. We don't know at this point, nor do we know how aggressive the state will seek to enforce it, but understand this is the law effective July 1, and unless the legislature changes it in a special session, which has not been called, this will be the law going into next year until the legislature meets, and even then it's not sure whether they will change the law. So let's go to now, and Mark and Lenny, I'll ask you to look at the various questions that we have. We have quite a few, so we'll try to go through them quickly. And if you have follow-up, just put it in the chat, and we'll try to follow up with it from that. So Mark and Lenny, let's just go through it. A couple of the themes that we saw in the questions are, understand this does not apply to employees that are currently there. This is only to new hires. And you saw Lenny talk about the idea of rehires, but it is only new hires. Number of questions related to what do we do about, we're 23 employees now. When does this law affect us? Because it affects only private employers with 25 or more. We simply don't know, other than to say when you get to 25 employees, I think you clearly need to start doing the E-Verify on that. It is unlike discrimination laws, which talks about the number of employees over a certain period of time. So Mark, Lenny, why don't we just start looking at the questions in the screen, and one of you take one of the three of us just take the questions that you see. Okay.
Yeah,
First question.
I'm going to take a couple. One is we're a Florida-based employer, but we got employees outside of the state. Our belief, I think, and Kevin and Lenny, tell me if you disagree, this would only apply to employees actually working in the state of Florida.
Yes.
Not to facilities in other states.
Yes.
So that would be that one. And there was one other one I saw that I would take. Somebody asked about J visas. Those are exchange students or exchange. They're not necessarily students. And the answer would be, do I have to e-verify J1s? And the answer would be, if you put them on the payroll, and there are some cases where they would be employed, then I would say you have to do it.
Okay.
Lenny, you see anything you want to grab?
Yeah, there was one, there's a couple. They're talking about our subcontractors that are paid on a 1099. Do they count as, toward the 25? I'm going to do the typical lawyer answer. It depends. Depends if they really are an employee or if they're a contractor. I mean, Kevin, Mark, and I can tell you that we've had many, many instances where employers believe just because they issue a 1099 that they're not an employee. There's more that goes into that determination. A lot of it has to do more with control. And we try, in some, what I'll tell you is, if it looks like an employee and smells like an employee, just because you give them a 1099 does not make them an independent contractor.
Yeah.
So can I add something to that?
Absolutely.
Already, I've been asked to look at agreements and where it's a legitimate agreement between two companies, right? And so our client is contracting, say, a janitorial service or some other service provider where it's pretty clear the workers work for that other company. My advice is you need to take a look at those agreements and make sure that you're imposing the obligation to comply with all laws on your contractors. This is separate and apart from what Lenny's talking about as a misclassification. One of the biggest penalties ever issued for I-9 violations was issued against Walmart because they contracted with a large janitorial service company to clean their stores at night. And the allegation by the federal government was that Walmart should have known or take better control to police what their contractors was. What they did. They did not contend that those employees were employees of Walmart. They just said, you should have known better given the facts and circumstances you had available to you.
Yeah, we're moving quickly here because we're running out of time. There's a number of questions about if you use employee leasing companies. The law specifically addresses that, and I'm paraphrasing here, but it's basically in your contract with the employee leasing company, who assumes the obligation to do the verification is the one that's responsible for it. You can expect the employee leasing companies, it's going to say it's your responsibility, but it's really a matter of contract for that. So you want to very carefully review your employee leasing agreements. And if you, as we get closer to July 1, you may want to specifically put in there who is responsible for that. Question about who should sign the MOU. The question mark was, should the HR director do it? That seems to be an appropriate person to do it, but Mark, any other thoughts on that?
Well, I think it also depends upon your corporate structure and authorizations. This is an important contract. And the question is, does the person who's going to sign it have the proper authority within your company to do it? Before I was a lawyer, I worked in HR for a Fortune 100 company. I didn't have the authority to sign something like that. That was an internal thing. So whoever signs it's going to be held accountable, and know what your internal, what your bylaws and also internal guidance says.
Yeah. Hey, Kevin, there was a question as to what qualifies as a temporary employee. Because again, when they defined employee, it says a permanent role, permanent employee.
Yeah.
Again, there's no guidance on what a temporary employee is. What I would tell you is, if you're hiring somebody for a specific job that is to last a specific period of time, that is probably a temporary employee. Now, if it's more than a year, I'd be a little bit more cautious. But if it's, for instance, you're hiring somebody to complete a project that you expect it's going to be for 6 months, I would say that's probably a temporary employee. It would not have to count 25.
Yeah, the definition of employee does talk about a permanent employee, then it gives an exception of casual labor, but that casual labor is only work done in a private residence. The reason I bring that up is I think you should assume a broad definition of what employee is, subject to what Lenny's earlier discussion about. We think seasonal employees and temporary employees will be excluded, but if it's someone hired for a position that's regularly in your company, I think that's the way to think about the idea that that person is going to be covered by this law. Just
there's also a question about, like, starting up new LLCs, so you're always below the 25. And there was also, I mean, keep in mind
about that.
Yeah, I mean, that could be used as evidence of knowingly employing somebody who's undocumented.
Mm-hmm. Yeah, I mean, frankly, if it appears to be too cute by half, it's probably too cute by half, because there is a body of case law not specific to this new law, but talks about aggregating employees when there's common control and things like that. There's a couple of marks I'm looking at.
About where do I get this information? Just Google E-Verify. It'll come up. I gave you the link to the user manual. There's a user manual for I-9s. If you Google this will easily come up. You can print out the posters off the internet. That should work. Somebody asked a question about using E-Verify through your HRIS system, which you don't own, right? So the idea is you go to a payroll provider or a PEO, but you're processing the E-Verify, but it's running through their system. Is that okay? My answer is legally it's okay, but I can tell you, I know, and I think Lenny has also had this happen. If you do that, you better be able to get the records if you're audited, because to give you an example, I have defended wage hour litigation. We're getting the payroll records, and for example, in New York State, there's a very long statute of limitations. So we get sued, and we need to get the payroll records from 4 years ago. Well, in the meantime, they switched from payroll provider A to payroll provider B. And the 2-year record, the longer records are with A, and we need to get those. Well, A's not happy that we switched to B. And there was no provision made at the time of the switch to get those records. And this may sound crazy, but this comes up a lot. And I can tell you there's certain companies out there have a reputation for not being very forthcoming with the records. So you can do it, but if you switch providers, make sure you get them before you tell them they're off. And if you don't switch providers, make sure you have an agreement that you have immediate access, because like I said, a I-9 audit can happen within 72 hours.
Yeah, we're about out of time here. We want to be respectful of people's time. Just a point of clarification based on one of the questions. The question was, you currently have 50 people working for you. That means you're you're an employer that has more than 25 employees. You only have to do the E-Verify for new employees after this. You don't have to go back in the past. And so what your employer size is 25 or more, you're covered, but you're only having to do the E-Verify of new employees hired after that.
And just one last thing. I see a whole bunch of questions. I thought we answered this. Let me clarify the contractor-subcontractor issue.
Yep.
You are not required to verify employees of your subcontractors or contractors. But
if you're a private employer.
Correct. But that's right. Thank you, Kevin. If you're contracting with the state of Florida, yes. But if you're a private company, a construction contractor, you're the general, and there are 52 subs on your site, you don't have to E-Verify the employees of the subs. What I was saying before, though, is you should take steps that in your contracts with the subs, that you make sure they agree to abide by these laws and adhere to it, so that you don't get accused of trying to use them to evade the purposes of the act. I think we're out of time.
Yeah. One final thing. Someone asked, I think, a very good question. Should the employer put in their offer letter that they use E-Verify? Yes. I mean, not only is it a law, but you're stating an intent to you be able to show that you are aware of that law and that it shows a step toward compliance. We will follow up on these questions, which we've not been able to answer, but we certainly appreciate everybody's time. And you have the slide deck will be made available to you. You have our email addresses. Please feel free to contact us if you have any questions. Mark, Lenny, thanks for the discussion. Anything else?
No,
if not, we appreciate everyone's time. Look forward to talking to you about this further. Thank you.
Thanks, everybody.
Thank you.